Because of time constraints, I will have to proceed to the final stage of this special event. I would like to give the floor to Mr. Terada Itsudo for his closing remarks. Mr. Terada is the special advisor to the Minister of Justice and the former Chief Justice of the Supreme Court of Japan. Mr. Terada, please, you have the floor.
Thank you, Komodo-san. First of all, to the participant who came from abroad, welcome to Tokyo. Perhaps this is not the best season to visit the city. You must be very courageous, and we are happy to have you with us. Now, we have had a wonderful session this morning on international dispute resolution. 4 speakers, Professor Kakiuchi, Judge Asakura, Judge Haruna, and Dr. Takatori gave us excellent overviews on Japanese recent developments in the field of international arbitration and mediation, together with a useful introduction of a newly designed specialized court for business disputes. We have also had a couple of panel discussions on international arbitration and mediation, which I'm sure you will have were not only informative, but extremely stimulating. On behalf of the people on the floor here, I'd like to express our gratitude to the speakers, moderators, the panelists, and the organizers for their effort to make these sessions a success. Before closing the session, I would like to talk a bit about further possibilities for improvement in the practice of dispute resolution. Let me begin with the history of Heisei period. It started in 1889 and ended in 2019, and explore the transformation and shift of allocation of state power and resources, which emerged during these 3 decades. In the first decade of Heisei, the main agenda set for the government was reforms of the existing domestic market structures, which are often criticized as being too restrictive for foreign investors and had to be changed in order to adapt to the coming borderless global market. Deregulation was the universal key concept in 1990s for many industrial countries, and Japan was no exception. The government was engaged in trying to ease or eliminate governmental, industrial, and service regulations one by one. As a result, low-cost carriers came into the aviation transport market, and buying medicines and medical devices online also became, to a large extent, legal. Restrictive regulations too were eased or removed for banks and other financial companies. On the other hand, the law of antitrust, intellectual property, and consumer protection law drew the focused attention of the legislators and were revised to give more teeth to the laws. The effect of this was that the revised law not only gave more power to the administrative authorities in those fields, but gave rights and remedies to individual victims or consumers, with occasional assistance from special quasi-public organizations, so that they could bring their cases to the court with fewer difficulties. Secondly, the government came to devote its energy to the crisis operations. Around the turn of the century, Japan was struck by two major earthquakes. It also suffered lengthy economic stagnation with a number of financial crises. People used to be against public money being spent directly to the private sector in general. However, in the process of recovery from the turmoil, people changed their minds and came to agree on large-scale public funds to be spent in the area of private banks or to be given to those who have lost their homes. The government actually moved quickly and decisively to finance these. Thirdly, as family structures gradually changed, it became clear that child abuse and domestic violence cases had increased in number. There was a huge public outcry as these cases were perceived to be intolerable. Before Heisei period, the public authorities were somewhat reluctant to engage in what they perceived to be interference in personal family matters. But something had to be done to tackle the situation, which were getting worse and worse. In the middle of Heisei period, new legislations were established in relation to these problems, in which the administrative offices, police forces, and courts were all given suitable laws to protect victims and to prevent further harm. Finally, major changes were made even in the criminal procedure rules. Fundamental reform was undertaken at the beginning of the century. Among its outcomes were the introduction of裁判員 trials and strengthening the power of the Committee for Inquest or Prosecution. Under the system of裁判員, major crimes were tried and judged by panels consisting of 3 judges and 6 lay persons called 裁判員. Thus, proceedings, once regarded as being the most distant from the democratic process, came one step closer to the general public. Moreover, through other legislation, victims of crime became entitled to recover damages in some cases, even in criminal proceedings. The Heisei period is often called the lost 3 decades. But if you look back at the history of the law in Heisei period, you will find a steady process of transformation was underway. The eyes and energy of the government are now focused more on problems in the private sector and less on industrial regulations when compared to 30 years ago. Administrative, civil, and criminal measures are in some cases mixed, and a distinction between the 3 has become relatively unclear. The courts now sometimes play roles which essentially and traditionally belong to administrative functions. Now, there's only one remaining area where a traditional system still dominates even after Heisei. That is civil dispute resolution. As described by the speakers this morning, where arbitration has its own tradition as a non-governmental measure for civil dispute resolutions, the government tried to make it more effective by amending the Arbitration Act. The effort also resulted in a new law on alternative dispute resolutions. Despite these achievements, however, civil dispute resolution outside the court seem to remain not as popular as expected. To improve the situation, the government devised a new plan in 2017 and has proceeded ever since to promote alternative dispute resolutions. They are probably aware that more effective practical schemes are required, and a breakthrough will probably come with governmental cooperation. When I was with the Supreme Court, I had several opportunities to discuss with fellow Chief Justices from other countries or jurisdictions over judicial administrations. We all agree that modern institutions which are engaged in dispute resolution and whose credibility is essential for them to be able to implement their duties, the top issue to be tackled had to be the provision of effective training for members of the judiciary in order for them to be able to keep up with the fast-changing society. This may also be true for arbitrators and mediators. I can see here a good chance of cooperation between national institutions and private ones for their mutual benefits. There should indeed be a wider frontier of cooperation between the two. Now, as we come to the end, let me close by expressing my wish that arbitration and mediation will find an ever better way to progress so as to become major players in the field of dispute resolution. Thank you very much for your attention. Thank you.
Thank you, Mr. Terada. On behalf of the co-organizers, I send my heartfelt thanks to all distinguished panelists, speakers, and contributors to this special event. And thanks to all the attendees for their participation. We here successfully conclude this special event named Future Prospects of International Arbitration and Mediation. How does the judiciary assist? Thank you once again and wishing you all the best.